Making a will is of course important, because otherwise I'm just sticking to the Hindu Succession Act. I have not seen the other, I do not know how the other communities treat it. You have to go to a lawyer who understands the Indian Succession Act or the Waqf Board Act, whatever is applicable to Muslims. Each person should find out what is applicable before making a will, right? So according to the Hindu Succession Act, children are class 1 heirs. So even if parents have divorced, for your own inherited property, which you have inherited, children are class 1 heirs. For your own property, you can make a will and give it away to somebody else. So many case, what happens if parents have divorced and then remarried? It doesn't matter. Your children get your inherited property by right, and your willed property, which is your earned property, you can give it to them. That you have a choice. But otherwise, children are your children. Even if you have divorced the person with whom you have had that kid, it doesn't mean the children's rights go away. Children's rights don't go away. So if they are your children, even if they have had a divorce, or if they are continuing to live with you, if they are major, minor, everything, they get the class 1 rights. Step children don't get any of the rights, but adopted children do. So if you have adopted a child, and this adoption has to be done legally, right? If you have just picked up a kid and said this is going to be my child, that won't work. If you have adopted a child according to the Hindu Adoptions and Maintenance Act, again 1956, then unless you have any specific reason, the children get the same rights as your biological children, or even if you have divorced, the children get the same rights. If you have adopted, they get the same rights. Step children do not get it. Children who are born with a live-in relationship, there is nothing clear about their legitimacy. The courts have held that if you have lived together for the last 10 years, 15 years, 20 years, you are like a married couple. But the law here is little uncertain. So if you have a live-in relationship and you have children, it is very, very important that you make a will. But please understand that if you have defied society and you are living together saying we will not get married, don't expect many of the society's security. Like for example, insurance is a social security provided, right? You pay the premium, but it's a device which is, so you have to be very clear that in case the nomination is your mother and you have a live-in relationship, the chances of your girlfriend being able to access any of that money seems to be very remote. Of course, she can go to court, etc. But the whole process, if the amount is 20-30 lakhs, she would not even go to court. If the amount is 20-30 crores, it may be worth going to court. But for 20-30 lakhs, how much of time, effort is she going to put in if your mother does not give her the assets? So you have to be very careful while making your will, especially if you have a live-in relationship. What will she get? What will your children get? The law is not very clear. Don't take a risk with the law. I am not for a minute saying whether you should live in whether there should be a live-in or no. I am saying if you are in a live-in relationship, documentation is far more important. Even if you are a gay relationship or LGBT kind of a relationship, please ensure that the documentation is done very well, right? Because the natural laws may not be so easily accessible to your partner, right? So you have to be worried about that. Worry about the documentation, especially if there are children. More and more you have to be worried about documentation, making the will, making sure that the nominations are right. All that is very important, especially in such cases. In other cases, at least you can go to the court. Welcome to Subramani. What happens in case of illegitimate children? Illegitimate children don't get a right over even your ancestral property. Your own acquired property also they don't get rights, but they can go to court and they may be able to force it. But the chances of getting the inherited property, what you have inherited, your children, if they don't give it to your illegitimate children, they can't get it. But your self-acquired property, you can give it to them. On that, they might have some rights. So one thing very clear, and when your children are minor, what happens? All these passing on may not be very smooth in case of disputes, etc. If you are married and your wife is willing to accept the responsibility for doing everything, then it's fine. If you are a woman and you have assets and you're sure that your husband will take it and manage it well, then it's fine. If you are not very sure, it is important to mention each of the children and put a guardian, put a executor, and make sure that the whole thing is very smooth. One thing very clearly, whether you have minor children, legitimate children, illegitimate children, or children born into you when you were in a live-in relationship, one thing very clear is you have to make a will. There is no doubt about that. Don't get carried away by somebody saying, oh, you can write it in a piece of paper and keep it at home, it is valid. Theory says it is valid. Try proving it in a court and you will run from pillar to post. It's much better to go to a professional, make a will, get it notarized and get it registered. One step is when you're in your 60s or maybe even in your 70s, just get it notarized. But once in your 80s and you're sure that you're not going to buy any more property or sell any more property, at that stage, make your will, get it notarized and get it registered. Do the full act, right? Step 1, step 2, step 3, making a will with witness and doctor certificate, etc. Then it is notarization and then it is registration. Go step 1 and step 2 you should always do. Don't even worry about whether you should do. Step 3, that is registration, helps. Especially when you're older, you might as well get it registered. Or if you're sure somebody is not going to buy any more assets, then it's worth it. Many of my relatives have sold or bought property in their 80s. Right, so don't be in a hurry unless you're very sure that you made your last move, then you get it registered. Otherwise, get just the nomination done. Thank you. Welcome to Subramani. I'm going to talk about inheritance. Inheritance from anybody is not just the money that we are talking about. It is also the memories, the albums, the jewelries, the electronic email accounts, all those things. All those are assets, right? So if there is a cryptocurrency, maybe that is also an asset. So all those assets, remembrances, everything belong to you. The question is, how can you get it? So first of all, when a person dies, the family may be in mourning, but within 21 days of death, you have to apply for a death certificate. What happens if you do not apply? Well, nothing much, but at least there is a process that at least before the 21st day, you should apply for a death certificate. What happens in case you don't have a will? Then you have to go and get something called a succession certificate. Getting the succession certificate is a tedious, boring process, and it takes 7-8 months, depending on how quick the lawyer wants to push the courts, and it's given by a local court. But you have to get that succession certificate before you can move, right? So whether it takes 21 days or whether it takes 7 months depends on whether there is a will. So crushing this 7 months to 21 days, or rather 21 days when you apply for a death certificate, you get it almost immediately. Let's say 30 days. So whether you want the assets to be distributed among whether the executor can act immediately or whether it will take time for him to act, depends on whether there is a will and or whether there is a succession certificate. So this 7 months, if you want to crush it, you should have a will, right? So how to make a will, why to make a will, I've done many videos on that, so I'm not getting into that in this video. This is a short video saying succession certificate is issued, I think, by a local gram panchayat or the local municipal the death certificate is issued by the municipal corporation or the gram panchayat. The succession certificate is issued by the local civil court, and which acknowledges the rightful heirs. So that is, if you have a will, do you need a succession certificate? In many cases, no. In some cases, yes. Some land authorities may insist on a will and a succession certificate. So sometimes it may be necessary to obtain a succession certificate even if you have a will. So check out your circumstances, but in 99% of the cases, you may not need a succession certificate if there is a will. So getting my house transferred from my father to my mother happened with a will. I did not need a succession certificate in Mumbai. It was a cooperative society. I do not know about everything. I am not an expert on making a will. Please